speaking for the Cathedral Outreach Committee. And we're returning to an issue that we've dealt with for years, the critical issue of the environment. I hate to say it, but David Altman, who's been a leading attorney in this field, especially a lawyer for the citizens and for communities that are seeking to get a better environment, whether it's air, water, or land. We started back in the 1980s where David did a forum that was on nuclear power plant. So David has been a forum speaker for years, and he's joined by his partner, Justin Newman, and the two of them and their firm has been really working hard over the years for the citizen and for communities that are dealing with environmental issues. Right now, they've succeeded in getting the EPA to restore a very needed tool, the Air Nuisance Rule, which was taken out in 2020 by the Trump EPA, and now it's hopefully being reinstated. But they need your help in terms of urging the EPA to continue this, and it's been an incredibly invaluable tool to them in terms of working with citizens. So I'll let them explain it to us, David Altman and Justin Newman, who are our leading community, if not part of the United States attorneys in this field of environmental law. David.
Thank you, Bill, and thank those of you who could join us today, and both on the internet and also live here. I remember very well one day after Governor DeWine's first shutdown on COVID, that Robin Burgess, who happens to be here today, called up sort of like the radar operator at Pearl Harbor and said, I think those are Japanese planes. No, Robin didn't actually say that. What she said is that we just got, it's in the Federal Register this morning, the day after the shutdown, that they're going to tend to take the air nuisance rule out of the Ohio State Implementation Plan. As Bill said, this was probably the most important air rule to communities, to citizens of Ohio, or the Ohioans. You don't actually have to, I guess, be a citizen to use the law, but it's called the Citizen Supervision, and it allowed you to enforce the Federal Clean Air Act. So we immediately went to work, which wasn't easy, given the fact that nobody was answering the phone and you couldn't get a news story out because, understandably, we were somewhat preoccupied with COVID, rightfully. But nonetheless, with the Sierra Club and their clients, the Ohio Environmental Council, Marilyn Wall and Donna Ballinger, who are our clients, put together an effort, and we had 1,600 or maybe more comments that went out that said, don't do this. And now, today, they did, of course, do it, despite having an illegal basis to do it, despite everything. So our clients, Sierra Club's clients, went to work, and we appealed this directly to the Sixth Circuit, which is Court of Appeals, which is that court that's just below the U.S. Supreme Court that covers our region of the country. And we came out with a good opinion that said that on remand, you have to consider a bunch of important things. And remand is when we return it back to the agency, the US EPA, to reconsider all the things it did wrong and decide if it can still figure out a way to harm the citizens of Ohio by keeping this out. And just on the 22nd, I think it was of February, was it? We got word that the US EPA, based on our briefing, based on what the Sixth Circuit very importantly said, the signals and they gave, that they were going to completely restore the air nuisance rule. Now, what does this mean? It ain't over till it's over. We have 30 days to get public comments that say something to the effect of, yes, we want our best tool that citizens have had to fight air pollution back. And we want, and so we support the full restoration of the air nuisance rule to the Ohio plan, which is called the state implementation plan. I mean, those details aren't important for today. And we need people to make public comments to the US EPA. And at some point, I don't know whether we have the address.
Right up there in the chat.
It's right there in the chat, whatever the chat is. I don't know all these terms, being of advanced age. But it tells you where you can get more information on where to send your comments, and it have us answer any questions that you might want us to answer. So in summary, before I have Justin come up here and explain a little more of this to you, because it's very important to understand what it is, fully understand what it is we lost, and that we and people like Marilyn Wall, the Sierra Club, have been using this provision for 50 years, the air nuisance rule, to get some justice in many cases. And we didn't learn until after the final decision was made to remove the air nuisance rule that there was actually one of our cases on behalf of two families down in the southern part of Ohio who lived, unfortunately, next to a company that we allege polluted their air pretty badly on a regular basis. That in order to get rid of that case, the lawyers, not the lawyers we were dealing with in the litigation, but other lawyers representing that company, actually met with the US EPA. We were never told about it. Met with the Ohio EPA, actually furnished the game plan to do this illegal thing, and that for 4 years we had been without the best tool. And people like Donna Ballinger and many other citizens that put in declarations in connection with this haven't been able to use it because it's not in the law. So restoration to help control, and Justin will explain a little more about this, this is key. But we have to comment as a group of people that breathe, live here in Ohio. We have to comment and support. And more importantly, I'm sure the people involved here will, but you're all part of other networks. The simple injustice, the illegality of this when it happened is an outrage. And as lawyers, we don't get, to be too emotional about it, but it's an outrage. To say that it was a mistake 50 years ago to put the air nuisance rule in to the Ohio plan and allow citizens to use it was a mistake. It just somehow slipped by everybody. And not only that, it slipped by everybody again all the times when the state plan was reauthorized and reapproved. Despite all of that, this mistake, that's exactly what they tried to say. If it sounds outrageous to you, understand it is. It's almost like saying the presidential election of last was stolen. It's almost like that. Although this is not a partisan statement, it is quite clear that there are certain things that are an outrage. And fortunately, that's why we have courts in this country, and they often still function. And that's what got us where we are today. And the US EPA is ready to fix this, but only if they hear from all of us, you and your friends and your networks and your organizations. And we'll help you we've got some talking points we can get you and whatnot, so you can be better informed about the whole thing. So right now, I'm going to turn this over to my law partner, Justin Newman. Justin has been with the firm in one capacity or another, but certainly as a lawyer throughout his entire career. And he is done superlative work in many areas of the law. Many of the things we've accomplished are due to Justin. And then, of course, our team, Amy Leonard isn't here today, but Robin, Jennifer, Amy Hartford, and the other lawyers that have worked on these things have done a marvelous job for the people that really need help. So Justin, without further ado, let me turn it over to you.
Something in the chat. Yeah, if you want to, here, you can read it.
Oh, I have to click.
There's just a comment in the chat.
Can you?
Yeah, you don't have to click on it. Just look at it and see if you want to respond.
It just says I do not see the information in the chat. Can you repost it?
Oh, okay.
Yeah, about where to send everything.
All right.
Yeah, we will. I know some folks have asked for information on where they can share their stories about the ANR, and we'll certainly will repost that. So, as Dave explained, the ANR is a very powerful tool that was lost for Ohio residents. Typically, when you bring a Clean Air Act claim, you would think you would need to rely on a lot of scientific information, a lot of scientific data, and the ANR, the Air Nuisance Rule, it was kind of was a tool for years to equalize the playing field between a community that was impacted by pollution and the polluter. And the reason why it was so powerful is that you could, one was due to the breadth of the provision. So if the air pollution was impacting your welfare, your use and enjoyment of your property, you were able, even without scientific data, to bring a claim against the polluter for that air pollution. And so for decades here in Ohio, communities, whether they be up in Dayton or in rural communities in Southeast Ohio, were able to use that tool to secure pollution reductions from facilities. And the way it works is these communities could, if they were being impacted by pollution, they could send out a notice letter to the polluter and to Ohio EPA and to US EPA. And if steps weren't taken by that polluter to reduce its pollution, the citizen could then go in to federal court and try to secure pollution reductions if the law was not enforced by the US EPA, Ohio EPA, or if the pollution wasn't reduced by the polluter. And so when that was taken out of the SIP, citizens were no longer able to use that tool. And so it put them in a position where they were bearing the brunt of pollution for years and not able to go into federal court in order to secure the pollution reductions. So US EPA was urged by one of the facilities that we were suing that the inclusion of this provision was a mistake, and that it was inadvertently improved as part of the SIP. But the fact is, all the evidence was that this was not a mistake. It was a deliberate choice by Ohio EPA to put it in the SIP. And for 5 decades, citizens used that provision effectively and meaningfully, and were able to enforce the law. And what I apologize. I'm just.
Question.
Yeah, go ahead.
SIP is a state implementation plan.
Yes. So in order for citizens to be able to enforce the law, that provision that they want to take advantage of has to be approved as part of the SIP and included as part of the SIP, which is the Ohio's each state has its own implementation plan for how they are going to meet the Clean Air Act. And so unless that provision is in the SIP, citizens can't use the citizen supervision and enforce that provision. So when it was taken out of the SIP by US EPA unilaterally, without getting input from, without investigating the role that it had for citizens for decades, it was taken out of the SIP. And then, so therefore, while it was out, citizens could no longer bring cases for 4 years during the time that it was out of the SIP. So, and where we are now is US EPA is proposing to put it back in. And so communities are going to have to, from all over Ohio, as Dave is talking about, are going to have to explain how important it is for them to be able to stop pollution from impacting their welfare, or impacting their health or impacting their property, and that they need to have that right put back in. And so so it's proposed to be reinstated right now. And so unless communities put in lots of input, and explain the importance of this, what's going to happen is we're going to have a very unbalanced record that's going to be made, because you can bet that Ohio EPA and industry are going to be urging US EPA to reverse this proposed reinstatement, because for decades, at least going back 10, 15 years, Ohio EPA has tried to take this out of the SIP without showing that it wasn't going to impact communities, and and then these local manufacturers and polluters have been trying to get out from underneath the ANR. So industry will be urging US EPA to reverse course and take it out of the SIP, not reinstate it. And so that's why the communities really need to provide their input and get this, have US EPA go forward with the reinstatement. So any other questions?
Is this a provision that exists in other states and not?
There's nothing quite. Other states have had provisions similar to this one, and the Trump EPA and predecessor US EPA iterations of the US EPA have tried to take those out of other states' plans. But what's unique about Ohio's is you had a 5-decade history of enforcement by citizens, and frankly, in some instances, Ohio EPA had even used it to enforce it. And you also had a very, unlike other states, you had a very clear record that this was a deliberate choice by Ohio EPA to put it in back 5 decades ago. And so, yes, other states have had similar provisions, but nothing quite as powerful that reaches impacts to welfare, impacts to property. And again, what's so powerful about this is if you're affected by pollution, you really don't have to put on data. You can put on evidence of not being able to open your windows, or every time you go outside because of this polluting source, you cough, you sneeze, you're losing sleep because of pollution. So it was just a really powerful provision with a 5-decade history of enforcement and use, and actually being used effectively. So
yeah, let me also chime in on that one, Justin, because it's a really important question, and that is the industry had argued that Ohio citizens had other ways to enforce this kind of provision, and the Sixth Circuit read their arguments in detail and said, not true. The air nuisance rule provision in Ohio law, in the overall Ohio system, is the way, it's a totally different rule that is aimed at enforcement of the law. and that the public nuisance laws of the state of Ohio are not a substitute, because that's what industry and even the government had argued. And that was, of course, totally untrue, like so many other things. And the Sixth Circuit shot that down. Now, I'll tell you something I can't say because the record was closed, but of course, when they made this decision, I can say I called the only person available to talk to me. This is before we appealed and all that. And I spoke to the lawyer who's a professional. I want to make it clear, the lawyer I spoke to was not working for industry. She's a professional who wasn't really handling Ohio, but she was assigned for whatever reason to handle this part of it. And I said to her, there is no way for Ohio citizens to enforce this law now in Ohio. And she said, oh, Dave, there must be. And I said, there isn't. And I said, I don't know. And then, of course, this is subsequently what the Sixth Circuit said, that this was unique. So that's the important thing. Many states have other ways to get to the same place. They don't need the air nuisance rule because they may have direct citizen suits under state law. We don't in Ohio. And the common law nuisance, like anybody can say, my neighbor's slaughtering cattle and the odors for the offal come over across the fence line. This is a nuisance. You can all sue for that, but that's not the same thing as the kind of enforcement mechanism that this is. And there's nothing like it in Ohio. There's no state citizen supervision. There's no equivalent. So very, very important. That's why March 25th, which is the deadline for these comments, is such an important date, because the citizens need to know that for many things they read about, the air nuisance rule would apply. It would be a violation that can get quick enforcement if you play it right and go get a preliminary injunction because you have the people testify. Mm-hmm. And guess what? We all have these little things called cell phones, and we can use, some people still have cameras, I guess, but you can go videotape what's going on outside. And then, of course, for many communities, with the help, we do get air monitors, but you don't have to have air monitors. And, we get air monitors and people actually can monitor and measure certain of the kinds of pollutants. And that's the kind of evidence that can prove up an air nuisance. So extremely important. And we've used it here in Ohio, many environmental justice communities. And by the way, Justin teaches environmental justice at the at least did at the University of Cincinnati. So he knows a little bit about that.
Yep.
All right. Any other questions? Yeah, Bill.
Well, it sounds like the effort to get rid of the air rule was air pollution rule was really because it had been effective. And so,
well, it was being used. It was inspired by being used in federal court right here in Cincinnati in front of Judge Barrett against a particular company whose super lawyers went to the EPA, US EPA and Ohio EPA and cooked up this deal. It gave them actually the game plan to get rid of it. And then, of course, but this, even though it was motivated, apparently, judging from who the lawyers are and what was going on, and what the Sixth Circuit talked about this. This is not just us. The Sixth Circuit looked at all the evidence and actually spoke about this. But this, of course, took this right away from everybody. And it certainly extraordinarily damaged the case that we had pending. And that case on confidential basis did settle, but it's a miracle because the key law that we were using was ripped out based on this scheme. Because if anything was entitled to be called a scheme, it's this.
Yeah, and while that company that we were suing in federal court was doing, urging the US EPA to take that out of the provision out of the federal law, I think the case that we tried in federal court is a powerful illustration of how that tool can be used. We were over here in front of Judge Barrett in Cincinnati, and Dave and I tried what's called a preliminary injunction, which is where you say, hey, this facility is an air nuisance. We want the court to stop that pollution from impacting these residents. And so what these residents were able to do with that tool was use what's called citizen science to collect air data that showed what they were actually exposed to. And then they were also able to go into federal court, and they and all their neighbors got their day in court, got to testify, talked about all the ways it was impacting them, having to shut their windows, not being able to go outside pretty much on a daily basis, and not being able to sleep at night because of the headaches that they were suffering from, all of these things. And so they were able to use that rule and testify in court about the way it was impacting their health, their use of their property, and use some citizen science that these little personalized air monitors that they had to show what they were being exposed to. And so really what that shows is that it's an equalizer for a community and for residents, because they can, document the violations and then go into court and testify about what they're being exposed to. And so it's really no surprise that, and what's going to happen is companies like the one that we were suing in federal court are going to urge that this remain out of the SIP, because they don't want citizens to have this powerful tool. They want them to have to be able to prove numeric or other types of violations rather than how it's impacting their health and their actual property. So that's really, I think it's a industry it doesn't like the fact that it's a powerful tool for communities that equalizes the playing field. And so I think that's why we need to all urge that it be.
And let me say, before we get to Robin's question, one other thing. The people I know, like many of the people watching, think lawyers, lawsuits, money. I mean, that's what you're thinking. You hire a lawyer to file a lawsuit to get money, like an accident case or something like that. And certainly when your life is interfered with and your property is damaged and all that, you're entitled to money. But the real point of these cases, and the real point of this law, and the important point of this law, is that you should use it if you possibly can to prevent money damages, to minimize money damages, to stop the bleeding, stop the pollution, in other words. And over my 40 years of environmental practice and 50 years of law practice, most people that come to us do not come to us and say, we want money. They come to us and say, we want to stop the pollution. And that's what these laws you're able to do, even if you haven't yet suffered a great deal in monetary damage. So keep that in mind. The word prophylactic, preventative, that's how these laws work. That's how they're designed. And that's what you need to be remembered. That's another reason why an air nuisance case, which, yeah, sure, you might find a lot of lawyers to bring when you're damaged that badly by the air, when your kid is died or almost dies because he's overcome by air pollution. Yeah, you'll find a lot of lawyers to do that. What we do is the prophylactic and preventative work, and it's called environmental law enforcement. And Congress made this possible because the Congress, a long time ago, knew, bipartisan wise, knew that there are reasons, political, corrupt, overwork, that agencies would not enforce the law. And citizen enforcement is vitally important. And there are key people in enforcement at the US EPA who have believed this for years. There are other key people, many of them at the Ohio EPA, who seem to have contempt for citizen enforcement. So if you're a citizen, and I don't mean necessarily that, I mean, if you're a person who lives in Ohio, you may want to root for the people who don't have contempt for citizen enforcement on this one and get your comment in, strong comment if possible, but any comment, and we'll help you, get you the talking points so you can do your own by March 25th. Now, Robin, you had a question.
I just wanted to, I think the one thing that you've always talked about is the safety net where, even if a polluter is in compliance with all the numeric permit terms, they can still violate the air nuisance rule. And so this really is another leveling the playing field where the citizens still have a tool to protect themselves when industry manages to get a weak permit.
Well, let me give you a great illustration of what you're asking about. Many years ago, many of you remember that we handled the BASF explosion here in Cincinnati. But let me take you back to Mr. Nelson, who was one of our clients in the firm, who actually the case Nelson versus BASF or Enmont or whatever it was, he was in the class action after the explosion. Mr. Nelson had always complained that how the emissions from the BASF or Enmont, BASF bought Enmont, and we sued both companies at one time or another for same kind of dumping. He had always complained that this was hard to breathe and it was possible. And we had some people from Channel 5 that went over there and they did some, and they actually experienced the nauseating and disgusting, almost made Jeff Hertz, who was a news reporter for 5, throw up at the time because he got nauseated, extremely nauseated. It was, one of those days that Mr. Nelson had reported to the agency. And Mr. Nelson, by the way, our local air agency labeled him a chronic complainer, but they never caught on to the chronic pollution that was coming out. And I'm not kidding you, that's exactly what they called it. But in any event, if we had realized in that case, and Mr. Nelson had come to us at that time, we would have used the air nuisance rule to stop that, because what was happening is the conditions were dangerous to the workers inside, the fumes from these resin kettles, and so they would open the windows. And all of the fumes would go out into the immediate neighborhood. In a great sense, this is often what happens. So the air nuisance rule is a true safety net, because if you can get around, if your pollution doesn't get to the monitor that's going to measure it because it's going into your lungs and the lungs of your kids, then next door, then this is a big hole. And that's one of the ways the air nuisance rule has been used to make sure the pollution goes up through the stacks, that where it's theoretically at least being treated, and then measured out in the community. If you open all the windows, and sometimes it's just that simple, and doors, and let all this stuff billow out into the surrounding community, you're never going to get an honest reading, because the people, it's the absorbers, the people, the medium, instead of some sort of medium in a collector, is the lungs, livers, and other organs of the people who live around that pollution. So it's a very, very important point. It is a safety net in many, many ways. And that's why it's so disastrous when this, based on a lie, was taken out. And the lie is, of course, that this was a mistake, because actually the only evidence in the record was an air official from Ohio that we were able to track down, who was part of the discussion. And the air nuisance rule was anything but an afterthought. It was deliberately put in because it was integral to enforcement of Ohio law.
One thing that might be confusing to some average citizens who aren't deeply involved in environmental issues. It sounds like the Ohio EPA is against this air rule. And so can you explain that to us?
Yeah, I'll try to tackle that. They're not against the air rule. This is what's interesting. They have the theoretical ability to use the air rule because the air nuisance rule is part of every air permit they've ever issued. But they don't ever hardly use it, except they claim they had never used it. That was part of the justification. Turned out that was not so. And on the day of the oral argument in front of the Sixth Circuit, after all these representations have been made about Ohio never uses it, they had to cut in front of the Sixth Circuit and say, yes, they have. Department of Justice said, well, we didn't know that. And the Attorney General of Ohio said, well, we didn't actually know it either. We found out last night. So it hadn't been very thoroughly researched. And in fact, it's been, and they've actually used it once in a case we have, but they don't. So it's part of Ohio law that what they want out is the citizens' ability to enforce it. And the Ohio EPA has a terrible record of ever using it. As a matter of fact, we have another case, which I won't go into detail on, that's currently pending in federal court, where there was a tremendous classic air nuisance. And the local air agency never even told the people that this was one that they went into all these other violations that potentially it could be and then ruled it, but they never even mentioned the air nuisance rule. And so, but that's why it's been there, because who are the people who know the most about the air nuisance? It's the people who live around. And if you have, and of course, if you're not giving honest testimony, any good environmental lawyer will not waste the time just because somebody says that. You verify things, and we know how to do that. And we have over the years. That's why we don't get our cases thrown out because somebody lied or something like that. We put a tremendous amount of work into that. But people think, oh, only a monitor can tell me about pollution. Testimonial evidence of multiple people is valuable evidence from which a court can decide an air nuisance. Plus, once you know about the problem, you can go to the state, without suing anybody, get records about, and you can the company that you think is the problem, and or multiple companies around. If you're lawyers or anybody that has technical knowledge and can help a community, a professor who lives in your neighborhood, for example, and you can look and build your case using testimony plus the evidence that comes from public records. And that's, that makes a lot of people uncomfortable because you can get to the truth. You may be able to manipulate your inspector. I mean, just take them out to lunch, buy them a hot dog, whatever. But you aren't going to manipulate the people who are sucking down the bad pollution. Although I will tell you, some people in the Ohio EPA think that a car wash token to get your car washed because of the air nuisance that that is a substitute. And that was the actual program at the old AK Steel as a substitute for doing something about what that same stuff was doing to your lungs. They would give you a token for a car wash. Not kidding.
Or a power wash in your house. Don't minimize it too much.
Yeah, I don't want to minimize it. Thank you, Justin.
Yeah.
If your house could take it, you would also power wash your house every now and then. If they thought, yeah. So this is what we're dealing with, and this is the record, on this, and yet the air nuisance rule applies in many of these cases. Ohio quite often, almost never will use it, but they have used it, and that's gotten them in a little trouble.
Well, and I think there are a couple of other points I would add to, the reality is that Ohio EPA effectively sort of almost brags and markets about how good its customer service is for the polluters. I mean, they just, their whole goal is to process these permits as quickly as they can. In the situation that Dave's mentioning, for example, with the old AK Steel plant, and oftentimes if a facility is subject to citizen enforcement, they'll run to the Ohio EPA and say, hey, this community is trying to enforce the law. What kind of deal, and try to enter into a deal with the polluter. And so the reality is Ohio EPA is often used as a way to block citizen enforcement and markets itself as more about customer service for the polluter. And then the other reality about permitting and how it works with Ohio EPA. Dave was talking about these numeric limits, and how with the air nuisance rule, you don't have to prove that the numeric limits are violated in order to bring an air nuisance claim. So the way these numeric limits are set in these permits is often the polluter with their consultants proposes those limits, and Ohio EPA frequently accepts them without any, pushback. And in some of these facilities that we've worked on, these limits are so high that the facility could virtually never violate them. I mean, just could never violate them. And so that's why if you don't need a numeric limit violation and you have the air nuisance rule, you can show that even if they're not exceeding the numeric limits, you can still bring an air nuisance claim. And it's important just because of the way these numeric limits are often just set by the polluters and their consultants, often based on just really ridiculous data. So
Yeah, let me tell you, I when you do this stuff representing the little guy, people with cows, but not 5 law firms, or a few grandkids they're trying to protect versus a big machine, a BMW driving team on the other side. You wonder sometimes, but I saw on NBC Nightly News the shocking development that Boeing has been regulating itself. And I thought to myself, I mean, and this is a revelation apparently to NBC, but this is environmental regulation in America. The polluter regulates themselves, and in some states, there's a really good job done. And the US EPA often, at least historically, except on this deal at the end of the last administration, literally toward the end, they made this decision after the election to go ahead and finally take this out after all the feedback and after all the comments. So every environmental, the way environmental works, you have a consultant for the company. You have outgunned kid that may not have a master's degree, might have a master's degree in something, working for the agency, and they're supposed to take this team of slick consultants that are paid a lot of money on the other side, and that's really who controls everything. The company's consultants, companies set doing the testing, very little or lax oversight on many of the tests. But so the air nuisance rule, isn't going to solve that, except when all that leads to interfering with the lives of actual people, and it's a chronic situation that goes on, and there's corroborating evidence, and then you look into the records and find more corroboration. Then you can go to court and you can get a judge to say, well, this looks like a nuisance to me. I've seen the video, I've heard the testimony, you got to cross-examine this guy. And then one thing I want to say, we can actually show you, thanks to the record made in the Sampson case, which is the case we were talking about, where the lawyers for that company went to the EPA. We can actually show you what an air nuisance looks like. That's public record, where the judge has let the video and the testimony into evidence. We can show you what that's like. And it's a dramatic imposition, and you see that, and you begin to understand why this is important. March 25th is the date by which you have to get your friends rallied. And
In the chat, can you read it?
what does it say?
Maybe in addition to the car wash coupons, polluting companies should provide coupons for bleach for neighbors' lungs.
Yeah, exactly. Whoever made that comment
Works for COVID.
gets it exactly. You don't even get the bleach for your lungs. They wouldn't give you that because they don't recognize that you're breathing this stuff, even though it's the air division that's handling this, not the car wash division of the Ohio EPA. It's the air division. It's to protect human health and the environment. So anyway, yeah, great comment. I hope whoever wrote that writes a very strong letter.
Robert?
Dan Zavon?
Dan Zavon.
Zavon.
Dan has been a legendary civic guy for many, many years.
Question.
Are there other,
Final comments from you all before you.
Justin, you want to go first and make it final comments?
I don't think yeah.
Yeah, all right. Well, my impassioned plea is March 25th. But get your friends. You may be contacting them ultimately anyway about other matters that you're concerned about life in America. Get your friends to write these letters. We will provide you with talking points, and call us, call anybody, critique them. This is a very smart crowd over the years that attends and hears about and maybe watches later this forum. But don't hesitate to ask tough questions. But let's please get this restored. We're on the verge of one of the biggest victories, and I've been blessed as an environmental lawyer to have been associated with our law firm anyway, and I some pretty big things in Ohio. But this will be among the biggest citizen victories we've ever had, if in fact we take the next step and push this across the finish line. So thank you for attending today.
I can share your phone number here for the
Okay.
people who home.
Jennifer's, is that 2 J's in it, but it's only supposed to be 1 J.
Oh, really?
Yeah.
Uh-oh,
Yeah, we'll get her.
okay. All right, so it should have
Oh, it's just 1.
1J,
Yep.
just 1J, okay. All right.
So
Wait,
that-
is that,
Did anyone read the address for?
did you want to say goodbye? Okay. We are finished today then. Thank you very much.
Here. Well, thank you, Bill.
Good job, you guys.
Thanks so much.
You're welcome.
Yeah, I'm both of them come to, the complexity of it. You gotta get all of that.
Yeah.
Yep. Well, this one is actually on a simpler board.